Because I say, when it comes to court with this, because I say, you should listen to the law laws and say, whether the system, what exactly are you doing? The first thing I want to do is political parties and whether that's on the council
to an extent, had that.
That has always been our position. That has always been our position.
With respect to political parties holding
and all of that.
you
You heard the decision of the Supreme Court.
What do you make of this?
Your initial reaction?
So we actually argued in support of the writ and the release, and we are happy that the Supreme Court has granted it.
Looking at the number involved for you, is this something that you're able to contend with?
I'm sure that are addressing in the judgment. So on the 5th, we'll see the full.
I guess this is a decision based on party deliberations. Did you consider the cost of holding election for all members and who should bear this cost?
I think the court was clear that within 1 year, all political parties must try to accommodate to this judgment. So let's read the judgment and we'll take it up. Thank you.
Verdict was very important because it sort of reaffirms our understanding of what had happened. That yes, the OSP needs authorization because the AG has exclusive authority to prosecute, and that authorization was given, if you see in the regulations that was done. So we didn't see a problem with it, but it comes to the same issue that we have raised, that for us, as far back as 2004, through the APRM and subsequently through many other policies, we all agreed that on the prosecution of corruption, we think that that power should be ceded to another independent body because of the conflict of interest that it creates with the Attorney General who sits in cabinet and who is a political appointee. So we still think that in the constitutional reform proposal, we need to go back to this and deal with. But at least now, the OSP can carry on its work until we get the constitutional reform.
Thank you.
I agree. I think that what the court has done is essentially preserve the AG's power to oversee all prosecutions. I mean, the thesis of a lot of people understand that the current constitutional framework placed limits on how far Parliament could have gone on some of these questions. And the way forward, I think the court gives us a clear direction that we need constitutional reform to fix some of the issues that have come up. And I think that has to be the underlying message. There's an appetite across board we can see for an independent process in investigating these issues beyond the Attorney General, and I hope that we carry that forward into substantive reforms.
One of the prosecutor said an administrative action that the AG will take. What would be advice to the office in respect to using this power and also keeping the independence of the OSP?
Listen, we have made tremendous progress on the issue already. The Attorney General has come out and said that he believes that he must give reasons whenever he exercises the non-prosecutorial power. It's something that I agree with, and I think that over time we may even begin to litigate the reasons as to whether or not they uphold the rule of law. So it's progress in every respect, I think.
Yeah, but we also have to note that the court said that power, because the discretionary power, is subject to Article 296. So I think that is where some of us have raised the question that Article 296C, which actually imposes an obligation for anybody with discretionary power to actually articulate, the parameters to which those are. I think that is still important. But as Oliver says, we really do need the constitutional process to try and fix and affirm some of these principles that the court has articulated today.